And we're back for round two. So, let's get into it a little bit here. This was the response from Walter Buren, who has provided us with all the CAFR information, the comprehensive annual financial report for cities, counties, states, etc. I learned about this back in 2016, and I've actually talked to Walter Buren. He's very brilliant, but again, in his expertise, like he says, I have no interest in learning what you're trying to teach me, Derek. I'm just here. I'm a numbers guy. And it doesn't matter if it's 1 penny, $1 billion, $1 trillion, quadrillion dollars. The accounting is what I'm good at. He's an accountant. Walter Buren is an accountant. And he is the one that discovered this excess of funds. And I was trying to explain to him that this excess of funds belongs to we the people. And he didn't want to concern himself with that. What he wanted to express is that the counties and cities and municipalities were lying to the American people and raising property taxes predicated on a 50-year projection. And that's why they're always saying that they're broke. But when he did the financial report as an expert accountant and CPA, when he discovered the CAFR report, he realized that they're all in the black. None of them are in the red. And I was trying to explain to him why they're all in the black, how they hypothecated our credit into existence and utilized it, and therefore they can't spend those funds from the spendthrift trust, but they can underwrite them as trustees. And because, again, the fiduciary trustees always have to be paid, and so they can underwrite the trust and the trust funds with a bond so they can get paid for their work. All right? Walter didn't have, he didn't want any of that information. That was neither here nor there for him, which is fine. Otherwise known as the other set of books. This is the private set of books on the private side of the ledger. Okay? Go to list of sureties. Why would they have a list of sureties at the federal district court? Again, sureties are what? They guarantee something, right? They could be the co-surety, the primary surety, but they're a guarantee in case what? The debtor defaults on their obligations. So when you go to the list of sureties, why would they have a list of sureties at the federal district court? Because the federal district court is buying up all of these default judgments from people being in dishonor, and they're turning around and bundling up all these bonds and selling them to investors. When you click on this, it takes you to www.fms.treasury.gov. This is the Department of Treasury. Then you will see on from Walter Buren, who has researched and spoken about the CAFR, Combined Annual Financial Report of Cities and Counties, the hidden set of books. This is the private set of books that they keep on the private side. Optional bids. It's all spelled out. The insurance companies are the weak link. The insurance companies are the weak link. They have the true liability. Remember what I told you in the first video. The whole economic system is predicated upon bonds, securities, excise taxes, and insurance. They have a true liability. They also, by the SEC, the Securities Exchange Commission, and fiduciary law, must disclose in their annual financial report any lien, encumbrance, claim, or judgment giving the dollar amount liability. And remember, the liability is a credit on the debt side of the ledger, right? And on the other side of the ledger is the assets. So you got the asset side of the ledger and the liability side of the ledger. And the credits are actually a liability. It's their liability. Amount liability and a short description, clear and comprehensive, of the liability. Okay? They also are holding trillions of dollars of real estate investment assets, real estate and property, of which are subject to patent attachment by claim. They truly are the weakest link. WJB. Here are my notes so far from 1 and 2 tapes of Jack Smith in which he's discussing and adding to Gene Keating's seminar. I'll send Gene's transcripts I've done so far for 2.2 tapes of the 4 Lynn. Jack Smith, number 1, November 1st, 2004. Gene handed out the paperwork at his seminar. He gave sample of the International Bill of Exchange. This is very important. This International Bill of Exchange, ladies and gentlemen, is bolstered and backed by the law of nations, okay? And we have the Bill of Exchange Act, and then we have the International Bill of Exchange Act, and the United States is absolutely bound to honor the International Bill of Exchange. A list of all corporations involved in prison financing. He had a number of sample bonds from the GAO accounting office. 3 come out of the federal court system, and 1 comes from the GSA, which is the bid bond, standard form 24, used for state cases. You can use these GSA bonds. It's important to understand why you can use them, how you can use them, and the foundation for which you're going to stand upon if challenged, right? He also gave me the Miller Act performance bonds. The Miller Act performance bonds are the federal bonds that ensure and assure the federal government won't sustain any harm, damage, loss, or hardship, okay? And so when you issue the standard form 24, 25, and 25A bonds, you also must issue the Miller Act bonds, which is going to be SF 273, 274, and 275. You typically see those in federal cases or grand jury indictments, but when you issue in the lower state courts and municipalities, when you issue the SF 24, 25, and 25A, you must issue the Miller Act bonds that insure and reinsure or reassure the federal government won't sustain a loss. Performance bond and payment bond reinsurance agreement in favor of the U.S. So the Miller Act bonds are in favor of the U.S., all right, for the federal system. He also had a 15-page prison treatise, which is dated October 10th, 2004, in which he wrote and describes what is going on with the prison system financing throughout the land. A man was offering a property in which the frontage was going to be taken on eminent domain. When they came to him for an offer, they said we want to take your land and only pay you pennies for it. The whole concept is they bring to you a series of negotiations. The first time they want to see if the transaction is possible, and the second, and then they go to the value of what the transaction will be. All right. And so a lot of times they're inviting you into their Article 1, Section 8 military tribunals, and it's an offer. It's an offer to see if you're going to come in and fill the role of debtor or obligor. And most people do. All right. And people go, well, they issue a warrant, and then that warrant comes out, and then we're taken in under threat, duress, and coercion. Being taken in under threat, duress, and coercion is different than volunteering. Equity will not aid a volunteer. All right? Jack has gotten emails from people that have shared copies of Treasury prepaid exemption bills of exchange, the forms of these, and one guy online has shared a certified copy from a public notary, a document that he attaches of any copy that he might make of something he provided. And he also sent a copy of the New York Executive Law Statute 135, Powers and Duties of the Notary. He did this because he runs into notaries who have no clue of what their job is. So he takes copies of the statutes of the state which authorize notaries to do things. Now, what they're talking about is called the notarial protest, okay? And this is very important to learn, and without question, you are going to have to cultivate your own notaries, all right? And I've cultivated many of notaries throughout my years because when they go to become notaries, most often they just get their notary certificate and their notary stamp, but they never pay the extra $2 to get the jurat stamp. A jurat stamp is for testimony that is given Many people don't realize that notaries have the ability to do depositions. Notaries also have the ability to, through the notarial protest, have the ability to create foreign judgments. Okay. And so the power of the notary is exponential. And as soon as you discover this and you start to research it, you'll find very quickly that you're going to have to cultivate a notary. You're going to have to train a notary. You're going to have to find somebody that has the same like mind as you and realizes something isn't quite right and wants to do something to enact positive change and correction. All right. And part of that is cultivating your notary. What I mean by cultivating the notary is you have to teach them the notarial protest. At sedum.com, there is all 50 states notarial educational books, and they teach you exactly how to do notarial protests and take it all the way to judgment for non-response. I'll just give you a brief overview. First, you have the first correspondence. That's a polite, friendly way of saying, hey, you fucked up, you owe me, or hey, there's a problem here, we need to fix this, we need to address this. They don't respond to that, let's say in 5 days. You go ahead and you start out with your first notice. Now, from the correspondence to a notice is a completely different, when you go from the correspondence to the notice, now we're actually taking action. When we get to the notice stage, now we're telling them, hey, this has been escalated. We are actually going to hold your feet to the fire on this. Remember, contract creates the law and equity follows the law. So when you did the first correspondence, that was clean hands and equity. Hey, let's come to some resolve. There's some issues here we need to resolve. We need to be in communication. We need to resolve these issues. You supplied them the evidence of the wrongdoing or evidence of the things that are wrong that need to be addressed and fixed. All right, that's a polite, friendly correspondence, and that's equitably clean hands doctrine. Okay. Then they don't respond to that. They blow you off. Now we escalate it to a notice. And when we escalate it to a notice, we're going to be using the notary who is going to execute the process of service. All right. And one of the things that I like to do with the process of service through a notary is content certified registered mail. Write this down. Content certified registered mail. Content certified registered mail means that the notary takes the documentation and the envelope, makes a certified copy of the documentation, has a secondary notary there to verify that it's a certified copy so there's no conflict of interest, right? And then that notary, the primary notary goes ahead and puts that content verified mail matter into the envelope and then mails it out for you. They issue the certificate of service. They use the certified mail or registered mail, depending on what you're doing. And then they create a certificate of service. It's sworn to under the pains and penalties of perjury that they, in fact, did mail that notice to the intended individual at such and such day, at such and such time. And they have in their arsenal a certified, verifiable copy, true and correct copy of the original correspondence that was in the envelope, okay? And they are going to be doing dictation, which means they're going to be keeping all of that documentation in a really nice either 3-ring binder or filing system for their records, okay? And you're creating what is known as a foreign judgment, and you're defaulting these people that you're sending your notice to. So your notice is sent out. They're given 21 days under the Federal Rules of Civil Procedure to respond. I do things a little bit different depending on what actions have been taken, but to make sure there's no confusion, we'll just leave it at that. Then 21 days passes, and of course the notary is the one who mails it out, and therefore the response from the notice needs to be mailed from the intended party. The response from your notice needs to be mailed to the notary. Okay, the notary is now a disinterested third party, okay, and they're keeping a true, correct, accurate record. And so in your notice, it says, this is the parameter of what's happening. It's my intent to bring claim nihil deceit, which means he says nothing, which means when you bring claim nihil deceit, they waive their right to trial. They waive their right to deposition. They waive their right to depose witnesses. That's all in your caveat, okay? And so your correspondence is sent to them, your notice is sent to them nili dicet. And so when they don't respond to the notary in the 21 days, plus 3 days grace for the mailing, then what the notary does is he creates a certificate of non-response. It's so important to follow this step by step, because every last one of these pieces has to be there in order to get your foreign judgment issued. Then you, of course, would create your second notice of fault, opportunity to cure, okay? So the first was a correspondence, then we had a notice. Now we're giving them notice to press claim nili dicet, and in the caveat states, they waive their right to trial by jury, they waive their right to preliminary hearings, they waive their right to any judicial action, so on and so forth, as far as a defense. The second notice goes out, and it's a notice of fault with an opportunity to cure, and typically with those, you can do, 15 to 10 days. All right. Some of the people that I work with don't even do that. One notice is sufficient because they're dealing with government actors that have an obligation and are fiduciary trustees. So 72 hours is more than sufficient considering the actions they've already taken. They must have all the facts readily available for the actions they take, and be able to prove that they didn't engage in treason, sedition, insurrection, whatever. Okay. But on the private side, you're typically going to give 21 days in your first notice. After that, 15 days, 10 days suffices for the notice of fault opportunity to cure. Same process. It's going to be content, certified, mail matter, being delivered through the United States Postal Service, but being put in the mail by your notary, who's going to have a secondary notary who's going to verify the contents in the envelope and create a certified copy, a true, correct, certified copy of the contents in the envelope. What this does is it provides for a disinterested third party to be a witness to the contents in the envelope. So often people send things out through the mail, but they don't have content verifiable or certified mail matter. And so yeah, we can prove that an envelope went from point A to point B. The question becomes, what was in the envelope? And anybody that's got their wits about them could easily defeat that. It then becomes a he said, she said thing, and now there's controversy, and we want to avoid all the controversy. So the notary goes ahead and sends out the second notice, which is a notice of fault, opportunity to cure, 10 days to respond. Again, the correspondence, the notice says that they're to respond to the notary, not directly to you. We're using a disinterested third party, so nobody can say they're being threatened, coerced, harassed, intimidated, any of that stuff, because we're not in direct contact. We're using a disinterested third party who's an officer of the Secretary of State's office, and for all intents and purposes, a notary is to be treated in their commission of duty as the actual Secretary of State, okay? So then the notary goes ahead and sends that out, issues a certificate of service, and keeps that in their file. The 10 days elapses plus 3 days grace. They don't respond. The notary issues a certificate of non-response, okay? Signs off on it, puts it in the file. Then you send in your notice of default, opportunity to cure, and you can give them 5 days, 3 days, 72 hours, whatever you're going to give them at that point. If they fail to respond at that point, in your notice of default opportunity to cure, you're going to include that this is confession and judgment. Their failure to respond at this point is confession and judgment to the following facts as stated herein. All right, so in the first notice and even the first correspondence, if it's a monetary thing, you're always going to have that monetary value already supplanted into your correspondence with the available receipts that are needed to prove the damages or the harm or the loss or the value, if you will, monetarily speaking, okay? And you're never going to change that number. I've helped people with this in the past, and they get to the default part, and they're like, yeah, now I'm hitting them for 1.5. And I go, where in the fuck are you coming up with 1.5? That's dishonorable. You're not acting honorably. You're no longer operating with clean hands. Where did you pull 1.5 out of your ass? You have to stick to exactly what you started with. It's not subject to change at the end because they failed to respond. That's not how it fucking works. So the notice of default, opportunity to cure, confession, and judgment. All right. And the caveat states that they agree to these facts and stipulated to the premise for your reason for sending out the notice in the first correspondence in its first place. When they don't respond to that timely, after the 3 days, the notary hasn't received any mail. 3 days later, because you got to have that 3-day grace period window in case the mailman, rain, snow, or shine, for some reason couldn't deliver the envelope, or the envelope got lost within the United States postal system, which sometimes happens, and we extend those 3 days of grace. Then again, the notary will issue a certificate of non-response, and this time you're going to have your notice of confession and judgment drawn up. You see, if you've ever been to court before, you'll realize really quickly that when the party that prevails, whether defendant or plaintiff, in most instances, not all, but in most, you'll find that the judge will say, okay, I'm ruling in favor of the defendant, or I'm ruling in favor of the plaintiff. And then if they've got attorneys, they'll look at them and say, counselor, I expect you to put that proposed order together and have it on my desk by the day's end. Okay? Because the court's business is always supposed to be wrapped up by the day's end. Now, they've gotten very lax about that. I realize some people are, told I want it on my desk by the day's end, and 3 days later, the opposing attorney or the attorney that prevailed is finally put the order together and it's on the judge's desk to be signed. All right? It's a default judgment issue. In this particular instance, you need to write your own order. The confession and judgment should be predicated on the facts that were established by their non-response. You don't get to embellish. You don't get to add. You don't get to ad-lib. You must stick specifically to what was sought in the form of the remedy and the restoration of your rights. Okay? So, once this is completed, you're going to sign off on that and allonge an affidavit as to the facts of the process that you utilize. On June 1st, they were given 30 days to respond. They failed to respond. I issued a 3 days grace. July 4th, I sent the second court notice. It was a notice of fault, opportunity to cure, so on and so forth. You're going to lay it all out. It's called a bill of lading, essentially. It's an index. You're just dictating everything that it was. This is going to go on the front of all your document. This is going to be the cover sheet, essentially, for your confession and judgment. And you're going to have all this documentation in order, okay? And now you have a foreign judgment. But once you have your foreign judgment, you're not done yet, okay? Now you go to the clerk of the court and you tell the clerk of the court, that you need this default judgment issued from the court. You're not actually going into the court. There's no litigation. There's no arguing. The facts have already been established. The confession and judgment is finished, and you have an officer of the state from the Secretary of State's office who has verified everything with their signature, has issued the certificates of non-response, who has issued the certificates of service. Okay, so there's no argument. At this point, you're just getting your default judgment. And the clerk of the court, so there's no need to pay a filing fee or anything. The clerk of the court is just simply going to take it back to the judge, and it's going to set in camera in chambers. It's a private foreign judgment. It's a private foreign judgment. It's not public, people. It's a private foreign judgment. You've already went through the due process of law. You've already done, you're holding court on your own. Okay? See, in the public, there's argument and controversy and this, that, and the other, but you've already gotten rid of that because your first notice to them after your friendly correspondence was your intent to bring suit nihil deceit, and your caveat stated that they waived their right to a trial. They waived their right to depositions. They waived their right to interrogatories. They waived their right to this. They waived their right to that. Okay? They waived their ability to turn this into a public matter. It's private. Well, then it'll sit on the judge's desk. It might sit there a week, might sit there a day, might sit there for 2 weeks. I don't know. I can't tell you how long it'll sit there. Normally, it's pretty quick. Okay? This does not require you to go in camera in chambers at all. This process that I speak of is the private side. It's your court. And you've removed all controversy and subterfuge, and you've followed due process of law, which is really notice and opportunity. They'll sign off on it. Once they sign off on it, then you need a writ of supplemental hearing. You can have a writ in supplemental hearing, a motion for a writ in supplemental hearing for writ of garnishment, writ of levy, writ of execution, and what's the other one? Writ of garnishment, writ of levy, writ of execution, and writ of bodily attachment. That way you can take your foreign judgment and you can lodge it in the commercial chamber, and that judgment is money. That's new money. Okay, and that's what we've been talking about all morning long, is how money is created and the ideology behind money. In the 73rd Congress, First Session, Volume 77, Part 1, that they didn't redefine the dollar, they redefined what money is, and they created this thing called an elastic currency. All right, so our bills of exchange, bankers' acceptance, trade acceptances, irrevocable letters of credit, they are all foreign currency to the United States. Those contracts that we create are currency. There's value and consideration. There's acceptance. There's expected performance. That's money, ladies and gentlemen. By the new definition by Congress in 1933, that's money. Everything you sign is either converted into a security or a bond in some way, shape, or form, which creates the new money, creates the extension of credit. And credit is the liability on the liability side of the T-ledger asset, on the T-ledger system for the banking. And then our exemption is what allows the credit to be converted into fungible funds on the debit side of the ledger, which is the asset side of the ledger, which belongs to us. So that's just a little tidbit on cultivating your notary, all right? Because what they're about to explain is the notarial protest. And I want people to understand how important it is to make sure that you have a notary that's on board. Now, do you need to use a notary? No, you can use a disinterested third party who's above the age of 18, competent to handle their affairs over all men, but you're also going to have to give them explicit written instructions because they're not allowed to practice the law. They're only allowed to do what you authorize them to do, which means you really have to know the procedure that I speak of. You should also be doing that with your notary. That way the attorney general doesn't come back and try and say, oh, well, your notary was practicing law. You didn't give them explicit instructions, which means that what they did of their own free will and volition, and they were making their own determinations, and therefore they were practicing law. All right. I've seen that done before, and that's why I am trying to express it to you the best way I can, that you must know what you're doing. You must have it in written form. You're the authority. You're the author. You're the source of the law. Contract creates the law and equity follows the law. So you need to be specific, and you need to also indemnify and insure anybody that's helping you with this process by giving them the instructions, because if they're thinking for themselves, they might find themselves in a position where they're liable. Okay? So it's important to lay it all out. You have the ability to do what I'm talking about. Okay? This is the power that's within you. This is what's recognized by the government. This is a Republican form of government that I speak of that has not been abolished. All right? So, and one guy online, let's see, all right. Gene is, in a seminar, said that you have to get a copy of the national version of P.M. Binos. They have copies of the sample forms in the book for notice of protest and certificate of protest. This is another important thing. Every time that you're doing something that deals with the notarial protest, there's certificates that need to be created, all right? Certificate of service, certificate of non-response, okay, certificate of process, which is essential in the administrative procedures. It's administrative procedures under the Administrative Procedures Act, the APA, all right? Now, on the private side, there is civilian due process of law, or just quite frankly, to be blunt, due process of law, which is nothing more than notice and opportunity, okay, with clean hands, pure intent. You have divulged all the material facts, what's true, correct, accurate, to the best of your ability. You've supported it with testimony in the form of an affidavit under jurat, and then you've executed your notarial protest, and you're vowing that everything is true, correct, accurate, not misleading, and their non-response, being silence, being acquiescence by tacit agreement and tacit procreation, has already been put in your caveat. So they know, and they've been duly informed, that their failure to respond is acquiescence, okay? Creating your foreign judgment. You have copies of the forms, which should be prepared by you and taken to the notary, but also having the book with you shows that a public notary who has written on a national scale has brought forth the duties of the notary, showing that it is a viable and necessary duty of a public notary. Under New York executive laws, it says, power and duty in general of notaries public who are attorneys at law, every notary public duly qualified is hereby authorized and empowered within and throughout the state to administer oaths and affirmation, to take affidavits and depositions, and to receive and certify acknowledgments or proofs of deeds, mortgages, and powers of attorney and other instruments in writing. Now, if you're going to create a power of attorney, you guys need to go to the Secretary of State's website. They have specific acknowledgments for these things. And if you don't use the specific acknowledgement, your documentation is deficient and default, okay? So don't fuck up and just use the typical notary acknowledgement for, say, a power of attorney, okay? And when you're doing testimony in the form of an affidavit, you need to use a jurat. It's very specific, all right? So you have to follow these rules to get the proper enforcement that you want, so you don't get any pushback. Every notary public duly qualified is hereby authorized and empowered within and throughout the state to administer oaths and affirmations, to take affidavits and depositions, and to receive and certify acknowledgments or proofs of deeds, mortgages, and powers of attorney and other instruments in writing, to demand acceptances of payment of foreign or inland bills of exchange. Foreign or inland bills of exchange. If you want to understand foreign and inland bills of exchange, you need to go read the Bill of Exchange Act of 1881 as amended and adopted in 1882 by the United States of America and all 50 states, including the United States. And you also need to go read the International Bill of Exchange as well. Again, the United States went into compact agreement to be underneath the law of nations, under the United Nations, and they are forced to acknowledge and accept your International Bill of Exchange. Remember, your Bill of Exchange, your letter of credit, your irrevocable letter of credit, your draft note, promissory note, trade acceptance, contracts, they're all foreign, okay? They're all foreign currency, and they have to be converted into the currency that's being currently utilized within the United States and evaluated as to their value, okay? The face value under 48 Statute at Large 112. Promissory notes and obligations in writing, and to protest the same for non-acceptance. Anytime they don't accept your note, draft, bill of exchange, bank acceptance, trade acceptance, they're in violation of not only public policy, but they're also in violation of 48 Statute at Large 112. They're also in violation of 40 Statute at Large 411, Section 7E. In order to get enforcement, you have to do a notarial protest, and you have to default them, okay? All these people out there, oh, I did this and it didn't work. Yeah. They cry and whine because they're spoon-fed. They don't fucking read for themselves. And there is no exception to reading, ladies and gentlemen. None. As much as I preach and I teach, there will be nothing better for you in your learning curve than to sit down and actually read this shit for yourself and cement it in your mind, okay? So there's no better form of gaining this knowledge than for reading it for yourself. And to protest the same for non-acceptance. Now, if you read the Bill of Exchange Act of 1881, it teaches you how to do the protest, okay? It's verbatim. It shows you exactly how to do it. It even gives you the damn documents. Out of Canada, the Bill of Exchange Act of 1881, as amended and adopted and changed in 1882, actually has all the documents for you when they fall into dishonor by not accepting your instruments or non-payment, as the case may require, and for use in another jurisdiction. Remember, everything that you're doing is foreign. You're getting a foreign judgment, but yet their public policy and their laws provide that you have the ability to draft, create promissory notes, bills of exchange, banker's acceptance, trade acceptances, letters of credit, irrevocable letters of credit, so on and so forth. And they have a duty to accept it. If they fail to accept it, then you need to get them for non-acceptance and a dishonor. And then you need to default them for their dishonor. To exercise such other power and duties as by law of nations. Remember, I told you, the United States in, 1948 or the early 50s, all the seats of government were conveyed and ceded to the United Nations, okay? And so everything falls underneath the law of nations now. And according to commercial usage or by the laws of any other government or country, may by exercised and performed by notaries public, provided that when exercising such power, he shall set for the name of such other jurisdiction. So there's plenty of background here that one can take these examples, documents, proof to public notaries so that you can work with them to get your remedies. Again, you're going to have to cultivate your notaries. You're going to have to educate them. You're going to have to find somebody that's like-minded, all right? In Gene's seminar, he made off-the-cuff a statement that sounds frivolous. And this is the reason I'm sharing this with you is because it's brilliant. But think about it. And the reality is there. Gene said, it's been a business doing pleasure with you. It's been a business doing pleasure with you. Okay? He made this comment when whoever he was transacting with ended up settling honorably. Okay? They settled honorably. Gene defaulted this guy with just mere words alone on a telephone call. And now we're going to get into the scenario of what happened. The particular settlement that Gene was talking about is when he had written a check on a closed account to Walmart for $600. If you don't know what you're doing, do not fucking do this shit. I'm going to tell you that right now. If you don't understand what has transpired here and you try to duplicate this, you're probably going to jail if you really don't know what the fuck you're doing. Do not do this because you heard this on some fucking TikTok or you heard this on Facebook. I'm telling you right now, this is years of studying. Gene's brothers were all judges. Some of them were federal judges. Some of them were lower court judges. I think he had 6 or 7 brothers in all. The guy was not a half-wit. He was not ignorant, all right? And the check on the closed account had gone through after the acceptance and the return and the request for post-settlement and closure to Walmart on an account. And as usual, Gene got back eventually in the mail a statement that said, your check's no good. It had insufficient funds on a closed account. It's going to come back to you, NSF, which stands for non-sufficient funds. They did not do any of the processing that Gene had explained to them, and eventually the letter said he'd better call the Walmart attorney immediately or they were going to have you arrested and prosecuted for fraudulent instrument. Now, let me explain this to you. Why this worked, okay? Because he presented to them a negotiable instrument. And there is a procedure under the Bill of Exchange Act, okay, for non-acceptance or acceptance for honor or dishonor of an instrument, okay? And they did not follow the procedure. So Gene knew that they didn't have a snowball's hell and chance of prosecuting him on a fraudulent instrument because they themselves did not follow the law of negotiable instruments. It can be either accepted and honored. It can be dishonored. If it's going to be dishonored, there's a procedure for it, and it's found in the 1881, as amended in 1882 Bill of Exchange Act. It's also found in the International Bill of Exchange Act. It's also found in UCC, where they tell you how to handle negotiable instruments. Under commercial law, you have 72 hours. 72 hours from the time of receipt to return said instrument without being in dishonor. Well, Walmart did not return the instrument within 72 hours, and after 72 hours, commercial law, they accepted the instrument, and now they're in dishonor, okay? So Gene called the attorney who asked what he wanted to do with the fraudulent check, okay? The attorney's asking him, hey, what do you want me to do with this fraudulent check? Gene never argued with him, okay? He didn't say, that's not a fraudulent instrument, that's not a fraudulent check, that's not non-sufficient funds. He didn't say that there's money there, okay? Because arguing creates controversy, and now you're going to court. Now you're going to an Article 1, Section 8 military venue, and you're going to get fleeced. You're going to get fucked if you don't know what you're doing. He said, you're an attorney, and you're holding the paperwork. What does he mean by that? You're an attorney. Gene's telling the attorney, you're an attorney, and you're holding the paperwork. He illustrated his intent. He articulated the proper process for negotiating it. And now the attorney's trying to call him saying, hey, you know, this is a bogus check. This is a fraudulent instrument. How do you want to handle this? You want to bring the funds down to me? He's trying to renegotiate a new accord and satisfaction, a novation, if you will. But see, Gene, all his brothers being judges, okay, some on the federal bench, some on the county level benches, is very astute to what's going on. He pays acute attention to detail, and a couple of his brothers said Gene knows more than we do, and we sat on the bench. All right? So Gene was very sharp. The attorney wanted to know what Gene wanted him to do. But the way the question is phrased, it leads you to believe that, you know, hey, I'll come right down, I'll pay that. The second you do that, you screwed yourself. You screwed yourself. You're admitting to something that you've done some type of wrong, that you're a trespasser, that you've caused harm, damage, and loss through some type of fraudulent activity, right? The attorney wanted to know what Gene wanted him to do. Well, I accepted it. I returned it. I gave you a foreign bill of exchange. It's a foreign bill of exchange. I'm requesting that you apply the consideration to the account in post-settlement and closure. See, this is what it's all about, remaining in honor. For the consideration to the account in post-settlement and closure, and ledger the account from the debit side, the private side, the asset side. See, that foreign bill of exchange is an asset to Gene, okay? That's the debit side of the ledger. To the credit side with the exemption, and settle this. What exemption is he talking about? Okay? Under the Exemption Act, you have an exemption, and you have to use that exemption, grant them permission to utilize that exemption as a pass-through so they can settle it on the public side of the ledger so they can zero balance it. The attorney came back and said, okay. Gene then said, it's been a business doing pleasure with you. Instead of a pleasure doing business with you, it's a business doing pleasure with you. Why? Because business is commerce, and commerce is war. And pleasure is going to peace. So when he said, it's been a business, it's been a war going to peace with you. Are you comprehending that? It's been a war going to peace with you. Blessed be the peacemaker, right? Doesn't that make perfect sense? Because the business was the transaction. The closure was the pleasure. Most people say it's a pleasure doing business. Business is warfare. Commercial activity is war. Don't believe me? Call a couple contractors and have them come give you estimates on siding or putting in a new sink in your house. Every last one of them is going to try and cut the throat of the other. That's because it's business. That's because it's commercial. That's because it's war. If your business is pleasure, then it is peace. His comment was worthy because that's where we ought to be going. Gene's seminar was really based upon the assumption and presumption that everything that goes through the courts, the Article 1, Section 8 military tribunals, particularly in the so-called criminal venue, is nothing more than a civil case seeking payment on a debt. The premise is that if you go into this business transaction, remember what I told you on the last video, all right? These Article 1, Section 8 military tribunals are really banks, okay? And the guy sitting on the bench is a banker, and the bench is a bank, and that's all conclusively proven through Black's Law Dictionary. So the nature and cause of the transaction is always going to be banking, administering a Chapter 11 bankruptcy. They're the debtors, you're the creditor, they need your credit, okay, to satisfy the instruments that they drew up in your good name using your credit worthiness, okay? As though you need to dispute some facts and resolve some issues, you haven't seen the handwriting on the wall and you haven't got a clue of what's going on there, and you are bound to fall into the trap that has been laid for you. All right. In the Bible, it tells you be wary of the ones who lurk in the shadows and lay snares to ensnare you into their artifices and schemes. All right. They're using a false conveyance of language and an artifice and a scheme to get you to become the debtor. They need you to come in and fill the shoes of their debtor. All right. They don't want you to be the surety. They don't want you to realize that you're the fiduciary trustee. Fiduciary trustees get paid. All right. They don't want you to comprehend that the debtor is, in fact, the all caps ens legis entity, and that they created a constructive trust for which you are the cestaqui, having cestaqui use of it, but you bear no liability. They're trying to get you to be in the position of bearing the liability and being in dishonor. Okay. So they can sell those bonds on the international stock exchange and profit from them in their retirement. Because their retirement portfolio is invested in mortgage-backed securities, which is exactly what happens when you fall into dishonor, because the public debt can never be challenged. Okay, so you've always got to accept it for value, accept the charges for value, and then you're going to demand that they use your exemption for post-settlement and closure of the account. It's very obvious once you see it, but it may not appear obvious until you get your head screwed on straight that the criminal matter in a court is a commercial draft. It's a commercial draft. You need to see the original organic charging instrument so you can properly endorse it and accept the charges for value and demand they use your exemption for post-settlement and closure. And you can look at an indictment as a bill of exchange. An indictment is a commercial instrument. A warrant is a commercial instrument. Whether you call it a put call or a check, it doesn't matter. Or a contract even, okay? And all they're looking for you to do is accept it and sign off on it and underwrite it because you are the source of the fucking credit. When you don't do that and you start arguing, you go into dishonor. And now they're able to sell those bonds, SF 24, 25, and 25A, 273, 274, and 275, all right, as a bill of exchange. If you take the premises that an indictment is a bill of exchange, then you come up with the conclusion that the three characters involved in the bill of exchange, that indictment, are different than from what you first believed them to be. Who is the drawer of the bill of exchange? If an indictment is a bill of exchange, any thoughts? The prosecutor? Well, he's an agent involved and he's going to represent the drawer. But basically, if they are following the pattern of reality, which is a big assumption and presumption, so that they actually do have a grand jury, because they might skip a step of reality and create a fictional grand jury and just come up with it by proxy. But assuming a grand jury exists, who is going to be to sign the indictment? It's the grand jury foreman that signs an indictment, ladies and gentlemen. He would be the drawer, okay? The grand jury foreman is the drawer of the draft. A draft is a negotiable instrument. Sometimes they're called sight drafts. They have a curation date of less than 90 days. Okay, a draft or a sight draft is something that has a curation date of less than 90 days. who is the beneficiary, the general public at large, the corporate fiction state. The drawee is going to be the bank, who is going to be to pay the draft. The defendant, straw man, your all caps ens legis entity, which is directly tied to the IMF, the International Monetary Fund, who issued the Social Security account number because your precious valued time commodity has been pledged to the IMF so the United States can do business internationally. So, an indictment, and again, to prove that, you need to look at the, it'll come to me, I'll get back to it, the Economic Stabilization Fund. So, an indictment is a check, okay? It's a check, a draft, a put call, all right? It's value. It has value. The problem is, until you tell them to use your exemption, it's setting on the liability side of the ledger, and they can't balance the ledger without your authorization, all right? When you authorize it with your exemption, now you can take these credits and we can transfer them over onto the asset side of the ledger where they become fungible funds and are debits, and you can use those debits for day-to-day transactions. It's a bill of exchange. And who is the bank who is supposed to pay the sum of money due? The defendant. Once the indictment is drawn up, the check has already been executed. Again, once the indictment has already been drawn up, the check has already been executed. The credits on account are there. They're on the liability side of the ledger. You need to use your exemption to move them over to the asset side of the ledger. Okay? You're coming in and you're authorizing the transfer and the transaction, and those credits are now going to be fungible funds that you can use. What's left in process? Collection. Who's going to collect? You're going to collect. Are we talking about a trial here? The trial's irrelevant. Why is the trial irrelevant? Because in their Article 1, Section 8 venues, there are no facts on the record or in evidence, and the law can't be tried. Okay? In their venue, it's all presumption and assumption. There are no facts. There's no real party in interest. There's nobody swearing under the pains and penalties of perjury that any of the facts are true, correct, accurate, not misleading. Even if there was an affidavit is nothing more than hearsay that allows lying by omission because they haven't been deposed yet. All right? So people saying that an affidavit is true in fact and law if it's unrebutted, to a degree, until you fully comprehend that an affidavit allows lying by omission. All right? Until you realize that an affidavit is nothing more than hearsay until the one that created the affidavit has been deposed. But that would be controversy. We don't want controversy because we understand all the charges are directly tied to penal sums and penal bonds. All right? It's a financial transaction. The check has already been drafted on a closed account. Isn't that something? Now, when you look up the definition of closed account you cannot put anything into. You can only draw upon. It's not drawn on a public account yet. So this check has been drawn on a closed account. How much is due? Law is not voodoo hooey. They have got a system to it. What Gene was telling us is that every statute that is passed by any level of this democracy government, remember the democracy government, okay, is their system. It's not the Republican form of government, the democracy side of it, okay? The business side of it. The United States Corporation and the subsidiary corporations thereof, including your counties and municipal corporations that are within it. That's the democracy they're always speaking of. Is a bond. Its purpose in passing the statutes, codes, city ordinances, rules, and regulations and attaching them to penal sums from the penal code is for the purpose of raising revenue. You have to wrap your head around that. You have to comprehend that how they create the new money in the system is through hypothecating your credit, attaching it to some charges, which creates the credit, all right? And then trying to get you to come in and either honor the agreement, accept it, acknowledge it for value, use your exemption for post-settlement and closure, or go in there and create controversy where they can sell the bonds for the penal charges and penal sums. Its purpose is in passing the statutes is raising a revenue. That's how they're raising revenue. That's why they pass laws, to raise revenue. Because why? All those statutes, codes, city ordinances, rules, and regulations are directly attached to penal sums and penal bonds from the penal code. It's like going to a fancy restaurant and ordering filet mignon and being awestruck when the bill is $2,500. Because, well, there were no prices on the menu. So you're not actually seeing the real charging instrument, because the real charging instrument actually has the value for each penal sum charged. All right? So every statute is a bond, and there is a value set on the bond. So every time the straw man, the ens legis, is charged in a charging instrument, an indictment, a warrant, whatever it may be, isn't a check a charging instrument. Why is a check a charging instrument? Because it's on the liability side of the account, the credit side of the account. The credit side of the account is the liability side of the account. Okay? So I'll reiterate that again. So every statute is a bond, and there is a value set on the bond. So every time the straw man, the ens legis, all capital name entity, when they're creating that constructive trust, is charged in a charging instrument, okay, a draft, if you will, isn't a check a charging instrument? Yes. Why is a check a charging instrument? Because it is on the liability side of the account. It's on the liability side of the account. On your T ledger, on your right side, I want you to write liability. On the left side, I want you to write asset. Okay? Because it's a liability side of the account. The credit side of the account. The credit side of the account is the liability side of your T ledger system. The credit side of the account is the liability side. The debit side, not debt, debit, D-E-B-I-T. The debit side is the asset side. You actually own both sides of the ledger, public and private, okay? But the debit side is the asset side. These guys are your fiduciary trustees, and you're going to tell them to use your exemption so you can zero balance the account, make sure the taxes are paid, because they're the ones that created this. They created this constructive trust, thereby they're liable. They carry the primary active degree of fault because they're in constructive possession of decedent estate property. And so they need to make sure the taxes are paid. And then the remainderment is then distributed to you in the form of debits. It's all backwards since they went to no money. And so every charging instrument is a credit instrument. Credit is what? A liability, okay? Not an asset. A credit is what creates the debt. A debt is also an asset. You have to understand how and why. And a credit instrument is a liability and is a sum of money due. It's a sum of money due. Your over-the-counter security is an asset to you and a liability to the bank. All right? There is no money in circulation, so every check is a charging instrument. It is going to charge the account, isn't it? When it goes to the drawee, the straw man, okay, the ens legis, all capital name, Sesta Vi Trust, which is not you, it's a thing in rem. So the straw man fiction, which is really the United States, which carries a primary active degree of fault for all debts, fiction, has been charged with a violation of the corporate statutes, and that has a valuation based upon the original statute and what its intent was to raise the revenue. All right? They're trying to get you to come in and argue and fill the role of debtor, carrying the primary active degree of fault and liability. You realize you can't sue yourself, right? So if you can't sue yourself, how does the attorney general and the attorneys, the district attorneys, sue their own entity? See, if you don't come in and fill the role, then they can't sue themselves because we can't sue ourselves. Remember, they don't have any rights that we don't have. They don't have the power or the ability to do anything that we don't have the power and ability to do. So if we can't sue ourselves, okay, they damn sure can't sue their own thing in rem that they created that's really insolvent and a debtor. All right? And they do it because people misconstrue the all caps name as something being of them. But it's something that creepeth on the earth. It's a legal fiction. It doesn't belong to you. It's not fucking yours. You have a right to use it, okay? But who carries a primary active degree of fault for creating it, owning it, and authoring it? The United States, okay? It's going to be a hard pill for you guys to swallow. It takes a lot of time to unwind the indoctrination you've been subjected to. So once the indictment, draft, cite draft, bill of exchange, negotiable instrument, contract, okay, the indictment, and we don't have to limit ourselves to indictment. After all, if in an information it's a charging instrument, if it's a citation, it's a charging instrument, and the whole issue is the straw man has been charged to pay the instrument. How does the straw man pay the instrument? By our authorization, being the attorney, in fact, on behalf of the principal, or us being the principal, authorizing the Social Security account exemption to be utilized to offset and discharge. What does this have to do with the trial and an argument? Abso-fucking-lutely nothing, because if you're at trial and you're in argument, you're in dishonor. You're fucked. There is no argument. There is no trial. This is a check. You either pay it or you don't. For those of you that are confused, because you've heard me for years and years say there's no substance in the economy, there's only 4 elements in this fictitious monetary system, and they are securities, excise taxes, bonds, and insurance. That's it. That's your whole fucking economy in this fictitious monetary system. So the only thing you can do is accept it for value, return it, demand they use your exemption for the post-settlement and closure of the account. All right? The post-settlement and closure, what you're telling them to do is to assess the value of the charging instrument, pay the fucking taxes, and remit all rights, titles, and interest back to you as you fill the role of the creditor, the shoes of the creditor. So you're entitled to the rights, titles, and interest. Okay? And so like Gene said, the charging instrument has already charged the straw man. Now, here's you. Are you the straw man? No. Did they charge you? No. You're a third party. You're a third party. If you get involved between the drawer and the drawee, what have you just done? All right? You now made yourself liable. You have become the party in the matter, and you have stepped in from the outside and inserted yourself between a couple of foreigners, and you have now become liable by your interference in their action. You ever seen two guys, two cockhounds going at it outside the bar fighting, and you think you're going to be fucking the hero and go break it up? And before you know it, they both turn on you and they're kicking the shit out of you. When they're done kicking the shit out of you, they turn around and go back to fighting themselves. Yeah, I'm that dumbass. I've done that a time or two. I don't do it anymore. I stay away from ignorance. I stay away from the bars just for that reason. But, you know, you try to do the right thing, and both of them turn on you and kick the shit out of you, and they go right back to quibbling and fighting and punching, and, yep, won't do that ever again. Right? So why the fuck are you doing it in these venues? Why are you subjecting yourself in? Why are you interjecting into something that has absolutely fuck all to do with you? You think you're going to go to trial and prove a matter. You are going to argue yourself right no matter how fucking wrong you are. You're going to argue yourself right no matter how wrong you are, and they love people like that. They fucking love people like that. This is a commercial charging instrument. This is a banking fucking transaction and nothing else. I don't care what the charges are. I don't care what they're saying. They're in an Article 1, Section 8, military tribunal, generating revenue, utilizing statutes, code, city ordinances, rules, and regulations that are directly attached to the penal code that has a penal sum attached to it. They are drafting and drawing indictments, warrants, negotiable paper, commercial negotiable paper. Okay? It has nothing to do with the trial. Why would we go to trial? The facts are irrelevant in those venues. No facts can be tried. No law can be put on trial. Because under Article 1, Section 8, military tribunals, under maritime admiralty, under the law of mercantile and the law of merchant, And the UCC, it's a banking transaction. That's it. That's why they'll tell you the cause, but they'll never tell you the nature, because the second you figure out that it's banking, you will change the way you do business, I promise. So the facts are irrelevant. It doesn't matter what anybody says in there, because it has fuck all to do with the actual nature of the transaction, which is banking. There's no law. We can't change anything anyway. What Gene was trying to show us is that if, in fact, the charging instrument is a check, what is the real purpose of the court? If, in fact, the charging instrument is a check, what is the real purpose of the court? To collect the payment from the drawee. We've got a bailor, bailee, bailiff situation here. We are the bailors. They are the bailee. They are the insolvent, defunct, de facto, Chapter 11 bankrupt entity. All right? And all they're trying to do is collect the payment from the drawee. That is the only purpose of the court. They are an accounting closing house. The court is an accounting closing house. It's a bank. The clerk of the court is a bank teller working at a bank teller window. The judge is a bank. The bench is a bank. All right? They are there to see if the drawee is going to settle and close the commercial transaction, which is the check which was written on the defendant. Like Gene said, the only remedy that you have is to go in as a third-party intervener on behalf of the drawee to settle and close on the transactional instrument which created the account. What is the account? The account number is the docket number and the case number. It's a bank account that's FDIC insured. The simple reality is that since it appears in their world that you, the living soul, are linked to the defendant strawman by name, if you don't come in and close the account, you are in dishonor, as any bank would be. If the bank does not pay the bill of exchange, which is presented to it for settlement and closure, if the bank does not accept and pay the draft written on it, it's in dishonor. And it, the bank, becomes liable now for the sum of money due. Since your straw man is, in fact, a dead entity, it does not operate itself. Living people operate the fictional entity known as the straw man, the ens legis entity. If you are a sovereign and responsible and a living soul, you have a moral and a commercial and spiritual duty as a fiduciary to honorably handle the affairs of the de facto corporation known as your straw man, which is really just the United States. You can either do it as the creditor trustee, which this is a very good position to put yourself in because the trustee what? Always gets paid. And the creditor has what? Rights, titles, and interest to the dividends and derivatives from the draft or the negotiable instrument or bill of exchange, or as the owner, operator, beneficiary of that trust. The choice is yours. If you are the trustee fiduciary, you have limited liability and the debts of the straw man are not the debts of the trustee. Nevertheless, you as the trustee have a duty as a fiduciary to help settle and close whatever commercial action come against the corporate de facto entity trust straw man. One of the ways you can handle that as the fiduciary creditor trustee is to offer the exemption of the living soul for the post-settlement and closure of the debts of the de facto corporate straw man if, in fact, you have registered on a UCC1 and have demonstrated by public registration that you have that status and standing to do that. Well, I've already shown you, absent a UCC1, 40 Statute at Large 411 Section 7E clearly points out that that certificate of birth is, in fact, in your constructive possession, and you're the holder in due course, making you the attorney, in fact, on behalf of the principal. So saith the commander-in-chief. All right? This is all under the Lieber Code, Executive Order 100, Articles 2, Article 31, and Article 38, that bolsters the Trading with the Enemy Act, which is the trust indenture that was amended in 1933, March 4th through March 9th. All right? This is huge. So even without the UCC in place, and remember, the UCC 1 being in place, you're just simply registering in the commercial chambers. That's all you're doing, showing that you have a lien interest against the all caps debtor entity. All right? Gene said that once an indictment and information citation complaint are filed in the court, a check has been drawn and the straw man is the bank. He is the drawee and is responsible for the debt. Okay? In the simplest way of explaining this is Henry R. Gibson's Suits and Chancery, subrogation, substitution, exoneration, and suretyship. See, the surety has the ability to compel the creditor to sue the debtor, sue the United States. Okay, and if the creditor doesn't sue the debtor, the United States, that ens legis entity, timely, and it may prove to be injurious to the surety no longer has to be or no longer can be held liable as surety, and the surety has grounds for an action. The only thing you can do as the trustee is accept the offer, return the offer for offer and consideration for post-settlement and closure of the account and the case. Otherwise, what happens in the court is very simple. The court recognizes that you, as the trustee or as the accommodation party, see, if you go in as the accommodation party, what's the accommodation party have to do? The accommodating party is the one who carries the primary active degree of fault for paying. Okay? This is when you go into some cooperative agreement, you become the accommodating party. Or you go into a joint business venture, and now they presume and assume you to be the accommodation party. Okay? The accommodation party is responsible for paying. But the accommodation party also has a scrupulous amount of liability attached to that ass versus the trustee has limited liability. But the accommodating party has unlimited liability to the defendant by your argument or your attorney public defender argument are in dishonor of your duty to pay the instrument. Okay? Don't argue. There's no need to argue or quibble. There are no facts before the court. There's nothing that has been entered as an exhibit before the court. You go in there arguing and boom, you're in dishonor. You're just there to settle and close the account and demand that they use your exemption, that you're accepting the charges for value, and you want it done post haste. And because of the dishonor, the court has to go to Plan 2. Plan 1 is to presume that presume the drawee or the trustee representing the drawee or any of the drawee's associates acting as co-defendant will pay the debt. Notice, we are not talking about findings of facts, arguing, or anything else. We're talking about paying the debt. Paying the debt. Plan 2 is Plan 1 failed because nobody is going to pay the debt. They are going to argue and be in dishonor. So Plan 2 is we are going to sell the debt to some third party who is going to buy the debt, and in order to hold a security for the outsider who bought the debt and paid the price, we are going to put the defendant, his associates, or the trustee representing the defendant in jail as surety for the third party who purchased the debt. Everybody that's in jail volunteered to be there. Everybody that's in jail volunteered to be there. Everybody that's in jail volunteered to be there. And we will hold them in jail as collateral to the third party until the time works the payment of the debt off back to the third party investor. The name of the game is you can settle and close the draft yourself as a trustee staying on the credit side. Or you can act like a lunatic and argue the case or do anything else you want and end up going to jail because you are in commercial dishonor. And somebody else will pay that draft in your behalf, but you will spend time in jail as the collateral for the payment until you work off the money over time. Don't they say people in jail are working off their debt to society? Now you know why they tell you that. So, So, part of understanding the background of what Gene is bringing to us is understanding the basic premises. Like Gene said, time and time again, they tell you it's criminal in order to confuse you so you will not know that you are there on a civil matter. Okay, it's a civil matter. It's a banking matter. It's a contract matter. Why isn't it criminal? They are insolvent and have no capacity to bring crimes against anyone. Not only that, to bring a criminal charge against someone requires a civil case to begin with. Well, don't they have civil cases? Isn't the straw man an asset belonging to the national government? Didn't they create him for the purpose of raising a secret revenue from the people? Don't they hold the titles and the commercial paper on the straw man birth certificate? So don't they have a civil cause of action? If the straw man is a 14th Amendment citizen, resident of the United States, a U.S. citizen under the 14th Amendment and amendment, does the straw man have the capacity to question the debt or raise a revenue of the debt, raising a revenue off the debt? If you truly understand the 14th article and amendment, and they have charged the straw man, which is a fiction, and not you, the living man, are there any constitutional protections here in place? No, absolutely not, because the Constitution does not protect fictions. It protects living people, and the government is not charging living people. It's charging the fiction corporation, and the fiction corporation isn't you. And the fiction corporation belongs to their civil society under their civil law and civil contracts. Okay? Maritime admiralty jurisdiction. All right? They've created this vessel, this entity. And we're fucking up and claiming it. And I only speak from experience. So what I'm telling you is it took a long time to see this for what it is. And I hope this is helping you guys out, because later on I'm going to show you some documents that'll blow your fucking mind. But they're true, accurate, correct, and not misleading, and nobody will argue them. So, by being a citizen resident, doesn't the straw man have a duty civilly by contract to obey the statutes and the laws of their civil de facto society? In other words, the straw man is in fact an officer of the United States. The all caps ens legis entity is in fact bound by the statutes, codes, city ordinances, rules, and regulations. All right? You bet. And if it violates the laws of the civil society, isn't it subject to the penal clause of the civil contracts to pay the fines and obligations of the violations of the civil statutes? You bet. Since he's a fiction and not real and not you, they can charge their own creation all they want. They are not charging you. Therefore, there's no constitutional violation or prohibitions. It doesn't come under the presumption of the de jure government. They're not violating any laws. They're not harming real people. If you want to step into this mess and be drawn in and get harmed as a result of your ignorance and actions, don't blame them. Don't charge them with destroying your government constitutional violations. They haven't done anything. They have created a world of illusion, and they have asked you to come into the matrix and play with us for a while at your own risk. Gene was saying here is where they go ahead and charge the straw man, and the goal is to see who they are going to capture by creating this fiction. Remember, we said a few months ago, it's a premise of law that you cannot sue yourself. If the straw man belongs to the very government that's brought the suit against their own straw man, aren't they suing themselves? You bet. Isn't that the height of a fiction and illusion? You bet. What changes it into reality? When a foreigner, you, steps into one of those characters, and now it's not the government against its own creation anymore. It's the government against a lunatic who stepped into this illusion and made it a reality, because now we have two different parties creating controversy. Gene talked about the concept of underwriting. On a lot of commercial transactions, you hear about the concept of an underwriter and what it is. What is an underwriter? In insurance lingo, isn't an underwriter someone who comes in and purchases a part or all of the securities that are being issued by a corporation to make a revenue? And the underwriter will lend his organization, his name, his character in order to purchase these securities and resubmit them onto the commercial marketplace for general purchases, exchange, and trade. When you are an underwriter, which got its name because you put your name under the person's name who was liable, you underwrote their name, assuming liability. You co-signed. You are now the accommodating party. You are now the surety, all right? The guarantee, if the debtor defaults, you're going to go ahead and take care of any debt due and owing. What is an accommodation party? Isn't an accommodation party one who lends his name to someone else and will be responsible to settle and close his debts if the other party does not do so? When they charged the corporate straw man fiction with the citation, the complaint, the cite draft, the indictment, the warrant, the information, the charging instrument, it's a check, and the banker, the one who's got to pay that check, is the defendant. Hasn't the defendant become liable to pay the instrument, the criminal charge? You bet. When you come into the case as a living party, you become the underwriter for a dead corporation defendant bank. Isn't an underwriter one who purchases the bond, all or part, to settle and close the case? So, when you as a living soul come into the criminal case without explaining what your capacity, again, it's capacity, standing and status and capacity is in that case, and without qualifying it, and the public defender attorney defending you won't qualify it, the court assumes you, the living man, are the underwriter of the draft to make the payment. Is there any wonder why the living man are the underwriter of the draft to make the payment? Is there any wonder why the living man goes to jail when the draft has been paid in post-settlement and closure, and you are, or your public defender attorney is still arguing the facts which are irrelevant? It's irrelevant. It's pointless to argue. Protesting your innocence and that you are not guilty of these facts. It never had anything to do with the innocence and that you are not guilty of these facts. It never had anything to do with the facts and the charges. They are irrelevant. It was purely a revenue-making device, and the plain and simple reality is you intervened not as an intervener creditor. You came in a general capacity as an accommodating party, underwriting and assuming the liability of the straw man defendant fiction corporation to the charging instrument, which was a check to be paid. You never paid it. You are in dishonor and you are in prison because you became the underwriter and you were responsible and the debt wasn't paid. They had to go to a third party. Do you understand what's going on in the criminal case? They're really civil in their nature. It's that simple. What Gene did was fill out a lot of information. One of the things he talked about is that by the time a charging instrument is created in a court, the charging instrument created behind it is called a bid bond, the SF-24. And the bid bond is the evidence of a sum of money due on the debt of the charging instrument to settle and close that account. Every time a criminal case is started in any court, a bid bond is already filled out. And what Gene was showing us through his research is that if it is a state court, the bid bond is most likely a GSA Form 24. And it says right at the top of that of the form, bid bond, if you are in a federal district court, the bid bond is most likely going to be a GSA Standard Form 275. It's the agreement in favor of the United States. Form 273 is the reinsurance performance bond, and standard Form 274 in a payment bond is a payment bond. Gene said there are 3 bonds for every case. There is a bid bond, a performance bond, and a payment bond. The bid bond is the bond that sets the value of the draft, the amount of money they are looking for to settle and close the case. A bid bond has already been issued when the case is lodged in the court. It's issued by the clerk to establish this. Gene said the federal district courts buy up all the state bid bonds. Why not? What happened in 1933 when the governors pledged all the assets of the corporate state to discharge the liability of the corporate United States? Wasn't that what the Constitution was all about? That the states became accommodation parties to the national debt, and in 1929 and 1933, when this was all called in, didn't the governors meet and turn over all the assets of the state to the United States to help settle and close the national debt? You bet. If the corporate state, New Mexico, Arizona, etc., are generating any income by writing bills of exchange on the strawman bankers for the violation of the state corporate statutes, doesn't it make sense that would turn over the proceeds of all that income to the feds to be applied to the settlement and closure of the national debt? And so Gene's research shows that the federal district courts are buying up all the bid bonds for all the criminal charges from the state and local municipality courts, and these are funneled up to the federal district courts and the clerk's office, where all of these bid bonds are assembled and packaged for sale to help finance the government. A bid bond is at the lowest levels, stating that the expectation of revenue is off this bill of exchange that has been written. The indictment is a bill of exchange, and the straw man is the banker who is supposed to bring in the money. Now, is the straw man going to be able to bring in money? No, unless the straw man holds assets or acquires income, and if he has income coming in or assets, won't eventually the courts garnish, foreclose, seize, levy, convert the assets of the defendant straw man to settle and close the account if the straw man's operators or trustees do not voluntarily do so. You bet. Isn't that what the courts do? Issue garnishments, levies, sail to close the bill of exchange? You never thought of a traffic citation as a bill of exchange, did you? You never thought of being charged with murder one as being a check that they were asking you for money. How much different is this scheme than what Martin Luther rallied against, the so-called indulgences? Well, we'll forgive you. Just send us your money. I bet you thought they got rid of the indulgences 400 to 500 years ago. Lynn's notes, Paul said there were indulgences that could be bought in the Catholic Church when he was growing up in the 40s and the 50s in New Mexico. Well, good news. Who do you think is running the civil law? Isn't it the Jesuits? Lynn notes, read F. Tupper Saucy, rulers of evil. Aren't you seeing exactly what went on before going on again? They just call it a different name so that you will be confused and not understand from history what is happening. So they are just asking for a little donation. Just send us a little bit of indulgence here and we'll forgive you if you can understand the process. Otherwise, we'll put you in jail and torture you a little bit and go through some inquisitions with you too. So the bid bond goes in. Since the government figures it has a sum of money due, isn't that what the bank is supposed to do, is pay a sum of money due on a bill of exchange? So they have the expectation of money coming in. This is before the trial, before the plea, before anything. After all, it is a check, and it's written so we can expect this to be coming in. So we gather these things together now, but they have a problem. What happens if they can't collect on one of these, but they already have planned on using it, right? The funds they feel are going to be there, and they are going to get them one way or the other, and they are planning on the fact that Bob Cook owes $500 on his driving without a license, so that we can patch the roads down here going into Cleveland. And we are going to, excuse me, let me scroll up a little bit, and we are going to hire a contractor to go patch those roads, and it may take a while before we are going to get the money out of Bob Cook, but we want to spend the funds now. So what are we going to do just in case by accident we can't collect the money from Bob Cook? We're going to insure it, and we are going to go to somebody that will put out the risk and say they are willing to pay Bob Cook $500 if you can't get it out of him or any part of it, in return for you giving me a portion of the expected $500. So what they do is they purchase a performance bond from an insurance company who gets paid part of what they are expecting to come from Bob, so that if Bob never delivers anything, the insurance company will have to cough up the whole $500 so the government can get the road done and paid for without worrying about it. That's called the performance bond. What Gene said is that the way the system is set up, the parties that will provide the performance bond can only be those parties which have already been pre-registered and pre-approved by the military. Corporate democracy government that has a list of all of the pre-approved sureties for performance, and you can usually find these on the administrative clerk's website in the U.S. District Courts. Who is approved to do this? Once the performance bonds has been issued to back up the bid bond, the government has now been insured against any potential loss of revenue from collecting from from deadbeats, even like Bob, who isn't going to pay it because he doesn't believe he owes it. If Bob stiffs them for the bid bond and the insurance company that posted the performance bond has to come up with the payment, where's the insurance company going to get the funds to pay off their claim? Remember, Bob's a deadbeat and didn't pay a penny. The insurance companies are in the business, and they have got customers, and their rates go up from providing performance bonds when the number of deadbeats go up. In essence, since all of society is a joint maritime venture, the good-paying members of the Admiralty venture always end up getting stiffed to take care of the liabilities of the deadbeats. Isn't that what the maritime venture is for anyway? Those people that are fortunate to have to pay for those people that are less fortunate. Isn't this called socialism? And so the land of the free and home of the brave, being operated under Admiralty Maritime commercial covering, is nothing more than a socialistic system. It's not capitalism at the highest level. It's being run on a commercially socialistic system. Oh, Facebook's warning me. It's just that in the background, this is what is happening and people don't understand it. And so they have been led to believe that the lie is the truth and the truth is the lie. And this is a private system of capitalism. Isn't the insurance compelled on all the capitalistic performers? The capitalistic players have to carry the maritime insurance. The system rests on socialism, not private individual capitalism. However, you can see that the intent of the civil military democracy government is to confuse most of the people most of the time to get full compliance with the Admiralty commercial system mandating insurance coverage by everyone. So, that the system without money can proceed, because when you have no money, you can't do business in private capitalism. The performance insurance companies provide performance bonds to indemnify the government, who gets 100% minus the cost of the performance bond to do business. As long as the cost of providing performance bonds does not eat too much into the gross receipts from the little scam, they're doing a very healthy business. As soon as the system breaks down and the cost of bonding and insuring the project goes higher than the reward of the project, then the system will probably fail. So far, all we have is an expectation of the revenue from the bid bond. And then we have and then we have a performance bond, which will guarantee something if we can't collect. But here is the problem. If we don't actually collect any of the money, who's going to get stuck to pay the cost of the government? The performance bond holder, right? If they don't get any revenue in, he's got to pay the whole thing. What would the premium be for the guy who buys a performance bond when nobody is making the payment on the bid bond? 100% plus more for administrative cost. Would the government maintain a revenue then if they had to provide 105% of the expected income to insure the system? No, the system would fail. How are they going to collect the money? Well, once you have all these bid bonds and they have been insured, double witness, can't you bring these together as security offerings? You bet. You can package these collectively as a security. What is a security? It's a promise that somebody is going to pay a sum of money in the future, right? Isn't that what the bill of exchange was? The charging instrument, the indictment against the so-called bad, heinous criminal? So, they're expecting eventually to collect some money out of him, right? On this check that they wrote against his straw man. So by the time they have the bid bond and the performance bond insuring it, they gather all these things together and they go to the securities dealer and underwriter. The securities dealer goes, oh, you have some checks there that should get paid. $10 million for Caleb, who emmed his girlfriend last week, and $500 from Bob, who drove without a license again, etc., etc. We have collected these again in billion-dollar packets. And now you take them to this underwriter, and what was the purpose of the underwriter? He's going to purchase all or part of the securities, make a market for them in the public, and resell them on the stock exchange. Now, if there's a company called Payne Weber that buys up all of these promises to pay by the tens of hundreds of billions of dollars and holds them as assets, shouldn't the value of the expectation of their future profits go up? And shouldn't the value of the Payne Weber stock increase because of that? What you have just done then, whoops, what did I do? Did I go too far? Boop, boop, boop. I must have went too far. Hold on. Underwriter. He's going to purchase all or part of the securities, make a market for them in the public, and resell them on the stock exchange. Now, if there's a company called Payne Weber that buys up all of these assets, shouldn't the value of the expectation of their future profits go up? And shouldn't the value of the Payne Weber stock increase because of that? What you have just done then is taken all of these bills of exchange, i.e. indictments, traffic tickets, information, complaints, and bundled them up as though they are income generating commercial items, and made a market where they are traded on the public marketplace, and investors can provide the money, and or we also expect that the people who are liable on the instruments are going to provide the money too. But some way, shape, or form, we are going to make the money by selling the guy's check to someone who will purchase it for pennies on the dollar in the hopes that he is going to go back and collect the full amount from the straw man through collection by attorneys and legal system, or else the guy's eventually going to make the payment and settle and close the account. Well, if he dishonors, then he goes to jail because they have sold the account to a stranger, and as security for the stranger's return on the investment, they are holding the living man in jail as the collateral, or the merchandise, if you will, to secure the securities, lending new interest in it. In what Scripture says, Babylon is just buying and selling the souls of men, putting them into prison, make a revenue to build the greater society. How did they trap you into their venture? They trapped you into their venture by naming a straw corporation after you, writing a check against their corporation, and hoping you would intercede and interfere with the help of your public defender attorney legally, that under commercial law you would become a voluntary accommodating party, liable for the debts of the corporate strawman. Who is to blame for the unfortunate circumstances that befall the people in jail? They themselves became, because they were ignorant, lending more credence to the Scripture that says, my people fail because of their lack of knowledge. They have been snared, and they have been taken because they do not know who they are, and they do not know who that so-called corporate government is. That is acting in a capacity of foreigners to God's people. If you go to the book of Proverbs, it will tell you many times that he who becomes a surety, an accommodation party for a stranger, a fictitious foreign corporation, he has no one but himself to blame. So what is the remedy? The remedy, as Gene pointed out, in his mini 6-hour seminar, he could take up to 3 days. We, as the living soul, have a standing, status, and capacity, if we understand who we are and how to do it, to issue both the bid bond, performance bond, and payment bond, and the underwriting bond as a foreign bill of exchange through the living party, not to be a surety and accommodation party for the debtor, but because of our status and standing as an outside creditor, come in and pay off these liabilities for the strawman corporation for post-settlement and closure of the accounting in the case, and it's gone. Once you do that, you've come in, and now you fill the role of creditor, and you're entitled to the rights, titles, and interests that the creditor was scheduled to receive. I know it's a lot to pack in one setting. I did a separate video earlier this morning. If you're just joining us now, don't feel left out or behind. You can always go back and look at that on my Facebook wall, as long as Facebook leaves it up. So, it's not about arguing. It's not about quibbling. It's about settling the debt. The public debt can never be challenged when you go in there and argue and quibble, not understanding what they're doing in maritime admiralty law, which is nothing more than pillaging, essentially, hypothecating your credit into existence without your express written consent, which could also be construed as identity theft. But we're not going to argue about those things, okay? We're going to get paid. Along with this, it's one thing to say that Gene done all this research and this is pipe dream. The criminal system is about protecting society against evil people. It has nothing to do with raising revenue. You guys are crazy. Well, okay, if you want to be in Neverland, that's okay. However, there are people out there who have been dealing with these issues, and the results are incredible. All right? There are real people, just like you and I, that are going out there and actually doing these things. And we have positive results, okay? We have sometimes proof. Other times there is no proof, okay? Remember, equity operates in the negative. And most often when equity is operating, there is no physical proof. They don't want you running around going, hey guys, this is how it's done, all right? For a lot of years, all this information was kept very quiet and amongst just a small group of people. Jack had a call from his friend Scott last week. He talked about him on tape. He was in prison and he did something to settle and close his case, and they threw him out of the federal prison into a private prison. Then he tried settle and closure for that, and before he knew it, they threw him out of the private prison. He was on probation. This has been for the last year. Victoria Joy was on probation in California also. If you remember, Victoria was on probation after they threw her out of jail, and she accepted that and returned and wrote a bill of exchange for post-settlement and closure. And before long, she got this strange letter from the other county saying she didn't have to go to a distant county to report in for probation. She could report in the county where she lived, to which Victoria responded, conditionally, I'd be happy to if you can show where they have moved a contract so that there is a charge for me to report. Remember, one of the things Gene Keating said in his seminar is that you must have a charge to accept, and if there is no charge, there is nothing there. And if you can't see a charge which has been issued so that you can do an acceptance and return, they may just be floating the possibility of a contract and an agreement by you. In other words, they're looking for you to volunteer. So, what Victoria did, she didn't create a controversy by saying she wouldn't report. She said, I'd be happy to show up at the county where I live instead of the distant county on proof of charge, that there is a duty for her to do so. The next thing she heard from them was basically, never mind. So obviously there wasn't a charge there. There was just an invitation to volunteer. If you remember, Victoria did inform the probation board when she was traveling here and there and out of the state. She wasn't asking. She was saying, if you have anything you want to contact me about, or you need some kind of authorization, let her know. She'd be happy to give it to them. So she acted like a creditor to the probation department, not as a defendant debtor. And pretty soon she heard nothing for a while. Then she went on the internet and she found that they had issued a warrant, and there's a warrant issued against the straw man. That would mean they were going to come after her and arrest her any place. She didn't think they were settling and closing the account like she had asked them to. So it appeared there was a new damage and she needed to get it settled and closed because the computer says there is a warrant. For a long time, Victoria and Jack were wondering that you couldn't charge these people, and so why was there a warrant there? This last week, Scott called Jack and said that the last time he had talked to Jack, they were going to hold a hearing. Scott didn't go to the hearing, but instead sent a request to see if they had done a post-settlement and closure. The next thing he knew, he was informed that a warrant was issued. Any of us, if we hear that the government entity has issued a warrant against our straw man, have the instant reaction and assumption and presumption that they are out to get me or to get us or to get you. Isn't that the instant assumption? What did Victoria assume? They are out to get her. They put it on the internet, and any time now when she is in Ohio, Florida, or somewhere else, they are going to look her up and go arrest her. Isn't that the presumption? Scott assumed that they were trying to arrest him. Jack asked if he had looked into it. He said, yes, I've got contacts. Scott had some acquaintances in law enforcement. One second. Scott has some acquaintances in law enforcement. Go on to the computers. And what did they say? They said that yes, there was a warrant there, but they did not think if they stopped him that they would pick him up on the warrant. The law enforcement acquaintance said he wouldn't risk picking up Scott because something looked strange on the warrant. Scott had an attorney acquaintance working in the government and called this attorney and asked him to look up the warrant. The attorney called back and said, dang, these people are trying to do that. The attorney called back and said, yes, there was a warrant there, but it was not the type of warrant on which anyone would arrest Scott. So Scott called the federal district court clerk and asked about the warrant posted on the account. The clerk admitted there was a warrant. Remember, the warrant is a check posted on the account. Scott requested a copy of the warrant, to which the clerk answered she could not do that. Scott replied that he had asked for post-settlement and closure, and she said, sir, I can assure you this case is closed. Jack has had other people tell him that when they had tender bill of exchange, they have been told that the case was closed. The clerk said to Scott, not only is the case closed, it's been sent to archives. Scott said he was still concerned about the warrant. The clerk said, sir, this is like an account warrant. An account warrant, okay? Sir, this is like an account warrant. It's not a warrant for bodily attachment. It's an accounting warrant. It's a check that's on the account, or something to that effect. So Scott called Jack and asked what he thought was going on. Jack asked, did Victoria ask the court for post-settlement and closure? Yes. Did Scott ask the court for post-settlement and closure? Yes. In order to settle the accounting, what do they need for settlement? Don't they need a draft? Wasn't the bill of exchange a draft on a private side? Many times when you draft them by a bill of exchange on a private side, does the account close right away? No. Why not? You need a second witness. Where does that second witness come from? Doesn't it have to come from the public side of the account? How is the clerk going to do the accounting on the public side unless she gets a draft? What is a warrant? Isn't a warrant a check or a draft? So when she posted the last warrant, that closed the public side on the account and they archived it. Victoria assumed the notice of the warrant was a potential arrest against her, and Scott assumed that when they posted the warrant as the last transaction on the account, it was a seizure warrant for collection against him. The warrant was the funds on the public side for the second witness to settle the account exactly like he had said, but they settled it by calling it a warrant to test Victoria and Scott to see if they were going to come in and reopen it by argument. They just didn't tell Victoria and Scott what kind of warrant it was. They gave Victoria and Scott half of the truth. We have got a warrant out on this account. Well, thanks. Doesn't that mean you've settled and closed now by applying the funds from the warrant to close on the public credits? See, there's two sides of the accounting, and it takes two bills of exchange, and that last warrant was what just might settle the court unless you are stupid enough to go argue and open it up again. We are our own worst enemy, but by not understanding the language and what is going on here. Lee's class member comments, the warrants are publicly posted for 90 days. This shows settlement. Jack, the clerk needs an order to settle and close the account, and that's what the warrant is, an order to settle and close the account. Lee, that's right. Jack, remember, we have talked in the past, and the clerk says she has the bill of exchange and can't do anything with it. So she just puts it in the file. What the clerk is looking for is a warrant on the public side to settle and close the whole account. And they call it a warrant, which is one of those scary terms that the public certainly doesn't understand, and we only understand it in the private when we understand what the warrant really is. It's an order and check to settle and close something. Lee, it could also be worded as a conclusion, a final statement. They can make that any kind of public posting they want. I've also seen it as order of the court, but it's a conclusion of the court, the final posting of the results of a hearing. It's an interesting what they will do, and they'll post it for 90 days, even though received nothing but, this is dead, this is closed. There has been no action, but there has to be a final settlement. That always concerned Lee, because 90 days passes and then it disappears. So did someone buy it? That could well have happened if you didn't close it. But they only do it for 90 days. So what happens if they don't sell for 90 days? Did they rename it and stick it somewhere else? There's a bit of confusion with the process, and this is the second time Lee has heard this condition of calling the posting a warrant, and they post it, and when you go in and try to find out what it's all about, there isn't any apprehensions. They are not going to apprehend at all. It's not like there's a debt left to pay. See, if you haven't paid the debt to settle the case, and when you pay the debt and you do the bill of exchange and the draft, it's on the private side. They need some kind of public order to duplicate that to settle and close the case. Lee, they need to reflect it as mirror. Jack, if that happens, it's good. On the other side of the coin, like Jack was shown here, if you default in not paying the debt on the private side, generally the court will enter an order of conviction against the defendant and all the accommodating party or accommodation parties associated therewith, showing the debt is in default. Now you can appeal that, but that's never a good sign. When you are on appeal, it means the account hasn't been settled privately and you are in dishonor. So why would you have a tendency to prevail in an appellate court whenever you appeal? Whenever your appeal going up is an automatic sign of your dishonor for having failed to settle and close the account. So the presumption on the appeal goes against you from the get-go, because you are a debtor in dishonor, and the only time you are going to win is if the procedure on trying to collect the account fell through the cracks on being grossly outside the procedures of honorably trying to collect the debt. That's all the appeal is, on the legitimacy of the proceeding to collect the debt. It's not the argument and has nothing to do with the argument. The issue that's being raised in the alleged case is on the moon. The appeal is only on the legality of the process they used in admiralty to collect the debt. Since you are up on appeal, you have dishonored the draft, and the party coming up and taking the appeal is in dishonor to the merits of the collection process. The appeal really doesn't do anything but shove it down the lower court for further collection processes. In other words, fix it. Lee has been sending out a packet, the Monday night packet, which has acceptance bills of exchange examples, signing in a fiduciary capacity about as much information as he could collect, reflecting that they have been going on Monday night. Lee waited all summer for the results of what they were doing before sending out the packet. It'll be updated again, but it's up to the point of the bill of exchange with examples how to notify Secretary of Treasury and handle conditions which have worked for others. He has included information showing how to do the acceptance and the following up and the certificate of dishonor. This is all instructional information. Yeah, I'm not going to